Okay.
Mr. People versus Lanto.
Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can withdraw.
And Mr. Lanto, then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be left alone.
Right out of the gate, you can already feel where this is headed. This isn't just another routine arraignment. This is a sovereign citizen, First Amendment auditor, and self-proclaimed victim of a broken system. Walking into a courtroom convinced he knows the law better than the judge, the prosecutor, and apparently his own attorney. And if the name broken system, broken trust sounds familiar, that's because this isn't his first rodeo. He's been here before, he's made the same argument before, and somehow he still hasn't learned how court actually works.
First and foremost, and then as far as an audio-only recording, I was told that there's an objection to the audio-only recording, and I'd like to know, I don't feel safe without a recording, so is there any reasonable objection?
Well, first off, you can't record in the courts of law. They're already, if you'd like a transcript, everything is already being recorded by my court recorder. And I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So, well, like I said, I don't feel safe without a recording.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair and meaningful hearings. And well, I mean, first off, I'd simply just like to be left alone. But other than that, I mean, to get fair and
I get that, but obviously you had an interaction with somebody where they are alleging that because today's the date and time set for the arraignment. So I want to make sure that you understand. I need to find on the date and time in question. It is alleged that, because first let me do the arraignment part, because you need to I need to let you know what exactly you're being charged with. All right. So you say you want to be left alone, but they are claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
This is one of those moments that quietly says everything. When a court-appointed attorney asks to withdraw this early, it's not about workload or scheduling. It's about compatibility and reality. Translation: the attorney knows that the defendant isn't interested in legal strategy, evidence, or outcomes. He's interested in ideology. Sovereign citizens often believe lawyers are part of the system. And once that belief kicks in, representation becomes impossible. The attorney is basically saying, I can't help someone who refuses to engage with the law as it exists. And notice what the judge does here. Calm, procedural, offering another appointed attorney without judgment.
Well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty, that's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to
Okay.
say anything, and it automatically goes to not guilty. So are
Well,
you pleading guilty, not guilty, or standing mute?
Well, before I make a plea, you stated that I have the right to be informed of the cause and nature of the charges.
Right, which is what I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened.
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. And that ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
Well, you sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law.
Well, first off, that's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video,
I'm going to take your response as being non-responsive, which is
well, I object to that.
Do with being guilty or not guilty. So I'm going to enter a plea of not guilty for you.
I object to that.
This is where the contradiction really starts to show. I just want to be left alone. Sounds nice. Until you remember how this case exists in the first place. You don't get arraigned for being quiet at home. You get here because there was an interaction in public that allegedly crossed a legal line. Sovereign citizens love this framing. They want the benefits of public spaces without the responsibilities that come with them. And the irony? He's a First Amendment auditor. Someone who actively seeks confrontation in public, now asking the court for solitude. The judge doesn't bite emotionally, but the logic is obvious.
Okay, then are you guilty or not guilty? Or standing mute? Those are the 3 things we got going on right now.
Well, I first have to clarify. You did say that I was presuming. I don't have to
clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is doing arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty, or if someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, that's the problem is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process, and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's it, and letting you know what the charge is, and letting you know what the penalty for it is. And I've already stated. So again, I'm going to ask you, guilty or not guilty?
This is a classic sovereign citizen pressure tactic. claiming fear, lack of safety, and mistrust of official records. Courts hear this all the time. The reality is simple. Courtrooms already record proceedings, and there are strict rules about personal recording devices. The judge explains this clearly, offers transcripts, and even suggests reporting misconduct if it ever occurred elsewhere. That's transparency. But notice how the defendant isn't reassured. That's because reassurance isn't the goal. The goal is to create doubt, to suggest wrongdoing without evidence, and to position himself as a potential victim before anything even happens. It's rhetorical armor, not a legal argument.
Nobody's trying to bamboozle you or anything like that. I don't know what happened in some other court, and everything that you want to do, you can still do. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you so that it preserves all of your constitutional rights and the case still moves forward.
Right. You said we're interested in preserving my constitutional rights, correct?
That is correct. That is correct.
And then one of those
what I'm saying is everything that you're saying can be used against you. If you think that you have a motion to dismiss, that's something that you can do, but that's when the case is already going to the next stage, which is
well, like I said,
of not guilty for you.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And then if we're not going to do that, then I definitely like to have fair and meaningful hearings. And my concern is we've got a police officer and we've got a prosecutor, both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a...
That I keep right here. Hang on 1 second. Copy of my... Sir, please, I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker, and I am not.
Well, I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to, and I'm telling you, I don't break my oath.
Okay,
so
would you agree
that implying that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens. And so So I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just said.
Or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted.
I'm not making a plea. I'm just finding you. I'm just entering. I'm just saying that you are right now presumed not to be guilty, because that's just your constitutional right to be presumed not guilty.
And then that means
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty, because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
Okay, and then, so if I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty. And you haven't had a trial yet. That's your other constitutional right. So
well, yeah.
We can just set this for a trial.
Well, we just said that I'm presumed innocent until proven guilty. And then my question was, am I presumed innocent of all the elements of the charge? And I didn't get an answer to that, because that's a yes or no.
This should be the easiest part of the entire hearing. Guilty, not guilty, or stand mute. That's it. The court is not asking for a speech, a manifesto, or a constitutional seminar. And yet, this is where sovereign citizen ideology completely collapses. The judge is doing exactly what the Constitution requires, informing him of the charge, the penalty, and his rights. Nothing more, nothing less. But instead of answering, the defendant keeps trying to drag the court into debates that belong later, if at all. This isn't confusion, it's resistance. And resistance during an arraignment doesn't stop the process. It just makes it longer.
Well, first off, I don't need to answer questions, and nor am I going to give legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly appreciate you being fair. Yeah, because
the answer to your question is I can't answer your question, because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gang mobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or Section 241 Title 18 conspiracy to violate my rights, then I have serious concerns for the fairness.
I am a judge of the 23rd District Court of the state of Michigan. It's located in the city of Taylor, but I am not. I don't work for the city of Taylor.
But do you see my concern for my safety?
I absolutely, except for the fact is I'm presiding over the whole case, and I'm going to make sure everybody has due process. Everybody has the same fairness to bring their case, and to make sure that they can cross-examine witnesses and make sure everything is reported by my recorder, who also has sworn an oath, and I find her to have never have broken her oath either. And so I'm just telling you, I'm going to be doing my job. My job is to defend the Constitution, and I will be doing so. So as of today, it was set for an arraignment. I have entered a not guilty as to the charges against you. And right now, I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties, where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set up for a jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Here we go. The magic words. Color of law. Sovereign citizens love dropping federal statutes, as if saying them out loud triggers some kind of legal trapdoor. But the judge shuts this down cleanly and correctly. Civil rights statutes don't magically invalidate criminal proceedings just because someone invokes them. Alleging deprivation of rights requires evidence, intent, and context, not vibes. And more importantly, those claims are handled in separate proceedings. This judge stays locked on one thing: procedure. He's not dismissive. He's not condescending. He's focused. And that's exactly why this argument goes nowhere.
Suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Okay, so what I'm saying is this. One, I don't have jurisdiction to take your case. Two, you're citing to federal law. Three, you would have to file that in the federal court. And and all of those things are available to you. You have the right to do so and have the proper court determine that. All right. So what I'm saying is this is a city ordinance, and I have jurisdiction over state cases and over city cases, misdemeanors. And I don't have, and what you're stating, I don't have the jurisdiction to hear. That doesn't mean that you can't bring that case in the proper court. All I'm saying is from now on, I'm just going to refer to you as Mr. Lanto. If you prefer not to be referred to as the defendant, then I'll refer to you as Mr. Lanto. The prosecutor is Mr. Dave Greco, and I'll refer to him as Mr. Greco. And that way, everyone will just refer to one another in their generally names. But what I'm asking you right now is, would you like me to set this for a settlement conference at a later date, Or would you like to set this for a bench or jury trial?
Well, I'm willing to forego any intention of criminal charges against the prosecutor if they're willing to just dismiss this.
I'm going to give everybody the opportunity to look at the case and think about it and not have to, I made sure that you didn't have to take a guilty plea right off the cuff without having to think about it. So I'll set this for a settlement conference. Settlement conference, and everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need to know which one you're choosing. So, all right.
Outstanding, because I'd like to talk to this prosecutor who I suspected.
This is an emotional turning point. The judge isn't angry, he's offended. And there's a difference. When someone implies that a judge is violating their oath, that's not a casual accusation. The judge responds not with ego, but with values, the Constitution, public trust, and personal accountability. This is a rare moment where the rogue comes off emotionally, without losing professionalism. He's reminding the defendant and anyone watching that judges don't represent the state as an adversary. They represent the process. And that process exists to protect rights, even when someone is actively fighting it.
And the next time it happens, I will hold you in contempt, because I will hold anybody in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. If you're going to I'm not referring to you as a defendant. I rightfully could. Anybody who has charges brought against them is for a moment known as a defendant. If you look in the dictionary and look up defendant, that's what it says. But you prefer not to be called a defendant, and I acknowledge that, and I'm going to call you Mr. Lanto. You are not.
Oh, sure. Thank you.
You are not, and I repeat, not until you prove otherwise in a court of law beyond a reasonable doubt. You are not to call any other litigant a criminal.
Sure. I've been alleged to be a criminal.
I will make sure that the proper respect is given to you. I'm going to ask the same of you. So you will refer to Mr. Greco as either Mr. Greco or as the prosecutor, but you're not going to call any other litigant or any other witness or anybody else a criminal unless they actually have a criminal record or they have been proven to be a criminal in a court of law by a jury of their peers.
Yeah, and for the record, I called him a suspected criminal. Well, I'm very careful with my words.
Again, you're splitting hairs, and I'm just telling you right now, I'm giving you one heads up that I don't allow any kind of Jerry type Jerry Springer stuff where there's going to be finger pointing, chair throwing, and name calling.
Well, I did do a cop watch karaoke, which is probably what led up. To this.
All right, so I'm going to set this for a settlement conference. All of your contact information is correct, so I can make sure that due process is afforded under the Constitution, and I'm mailing notices out to the proper spot, and that's the Cloverdale address.
No, and at this time I don't feel safe giving an address, but I'll give you a phone number and email address that I can be contacted by because I do want to participate in the settlement conference.
All right, but I also need to. I'm required by law to mail it out to your last known address. So. If this address is something that you will still receive, all I'm saying is I already have an address. I don't.
Yeah,
no. Is it still current? Is it still
in
current?
In the activism that I do, it's infamous to me, so I prefer not to.
Well, then that's up to you. That's up to you to go to the. It is incumbent upon you to go to the post office and make sure that they have your forwarding address. I'm going to mail. My clerk is going to mail it out to the Cloverdale address. And if you didn't put a forwarding on there, well, that's between you and the post office. We don't send out emails as notice, and we don't make phone calls to let people know when the notice is. We use the mail system because that's the only thing that's tangible and can actually be proven. Why? Because you can see that you put something in the mail. You can actually see that it's been in the mail because it's post-dated. So
yeah, is it going to be certified? Because that's the only way really to prove that somebody got it.
No, it's not, and we don't have to send it by certified mail under the court rule. And the court rule has already been ruled to be part of the Constitution, and it's already been ruled as being constitutionally proper under due process of the Constitution. So I'm going to mail it to your last known address. If you have some sort of change of address, that's between you and the Postal Service. All right. So we're gonna set
Well,
this
yeah,
for a
'cause it-
second conference date. It'll be sometime in the new year, sometime in January, and we'll see everybody then.
Okay, I certainly appreciate you being fair.
At the end of the day, this case isn't about conspiracy, secret statutes, or government oppression. It's about procedure. The judge did exactly what the law requires: explain the charge, protect the defendant's rights, and move the case forward despite nonstop obstruction. This is why sovereign citizen arguments fail in real courtrooms. They ignore structure, timing, and jurisdiction. Rights exist within the process, not outside of it. If you found this courtroom exchange as revealing as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns where ideology meets reality.